In 1954, the Supreme Court ruled in Brown versus the Board of Education of Topeka, Kansas, that segregation was inherently unequal and therefore unconstitutional. And it was about schools, but everyone knew that what it really was about was that the whole system of segregation that included voting, included public accommodations, it included every aspect of life. That whole system of segregation that the South had established was now considered unlawful, unconstitutional. And that was a day which essentially meant that Plessy versus Ferguson, handed down almost 60 years earlier than Brown, that 60 years of Jim Crow, of blatant segregation, was declared unconstitutional. Now there was going to be no longer separate and unequal. But the real problem was how to make the South live by that decision. All the southern states began to figure out how they could resist the order. How could they overturn the order? In Georgia, there was an immediate response. By 1956, the Georgia legislature passed several laws, including one which changed the Georgia flag and put the old Confederate flag into the state flag. Now, some have claimed that that was simply an act of celebrating the history. In truth, anyone can clearly see that it was enmeshed in the whole business of massive resistance against Brown versus the board. The legislature in that session, when they passed the change in the flag, also passed laws getting ready to dismantle public education. They passed a law that would allow public schools retirement funds to be transferred to private schools. They passed legislation to allow public schools to lease to private schools, which did not have to follow Brown, their equipment and their buildings. The 1956 legislature primarily did nothing but get ready to establish the mechanisms by which to resist Brown versus the Board of Education. By 1959, the NAACP Legal Defense Fund had challenged the resistance to segregation in the courts and had gotten a federal court order from Judge Frank Hooper that the Atlanta schools would have to be desegregated. Immediately, the Governor Vanderveer, he set up a commission which was to study what to do, how to resist, and how to handle this fact of a federal court order ordering a specific integration of the first schools in Georgia. Governor Vanderveer appointed a lawyer and a businessman by the name of John Sibley as chair of this commission that was to study the question. The Sibley Commission prepared a report that essentially said that we should not close the public schools of Georgia to avoid integration. And it listed a dozen ways in which to frustrate integration. So as a result, the Sibley Commission's recommendations were used to assure that desegregation would occur very slowly across Georgia. It gave Georgia state officials a lot of suggestions about how to frustrate the desegregation process, how to slow it down, how to assure that if it occurred at all, it would occur very slowly with many delays. And one of those techniques was the notion of simply saying that we will admit a token number of African American students and arguing that that was desegregation because it ended segregation. There were other techniques as well, but the Sibley Commission's report essentially was the blueprint that assured that desegregation of our schools in Georgia would occur one at a time, very slowly over a period of several years.